Ever feel like trying to understand the rules of the Philippine legal system is like staring at a giant instruction manual written in another language?
Oh, absolutely. You're definitely not alone there.
Whether it's a tax problem or untangling a property issue or maybe just wanting to know your basic rights, the sheer amount of information, it can feel, well, overwhelming.
It really can. I mean, the legal framework is designed to be thorough and fair, of course, but all those details, they can sometimes make it hard to see the bigger picture, to understand what it all means for you.
Well, that's exactly what we're tackling today. Think of this as your personal shortcut through that legal maze. We've got the CODIGO Remedial.pdf excerpts you shared with us.
Right.
And our mission really is to pull out the important, actionable stuff, without getting totally lost in legal jargon.
And it's worth remembering that, you might be coming to this with a lot of background knowledge already, or maybe this is all pretty new territory for you.
Good point.
So while we will be looking at specific details, our main goal is clarity, to give you insights you can actually use, not just throw more complexity at you.
Precisely. We're going to cover quite a bit. Everything from figuring out which court handles which kind of case jurisdiction, that is, to the step-by-step of how lawsuits work, different types of legal actions, even some rules for criminal cases. Ready to dive in?
Absolutely. Let's start with where the battles are fought, so to speak, jurisdiction.
Okay, let's begin with taxes. Always a fun topic.
Oh, indeed.
Our sources point to the Court of Tax Appeals, the CTA. So this is where you'd go if you have a disagreement with, say, the Commissioner of Internal Revenue.
That's right. Think about questioning how much tax you owe, asking for a refund, dealing with penalties. Basically, anything that falls under our tax laws or BIR rules. The CTA has exclusive appellate jurisdiction there.
Exclusive appellate. Okay,
Yeah.
so they review decisions.
Exactly. Now, if we switch focus to more general civil cases, the ones that go to the regional trial courts or RTCs, we see a different set of rules for what kinds of cases they handle initially. Original jurisdiction.
Right, and this is where it gets really interesting, especially if you're dealing with land or property. The RTC has sole authority, is that right? For cases about ownership or possession?
Sole original jurisdiction, yes, but only if the assessed value of the property is over P400,000.
Ah, the assessed value. And there's a catch, isn't there? Like forcible entry cases.
Exactly. Forcible entry, unlawful detainer. Those specific possession disputes go to a lower court, usually the MTC. They have their own track.
Got it. What else lands in the RTC initially?
Well, Admiralty and Maritime Actions think ship disputes where the claim is over P2 million.
2 million pesos. Okay.
And probate matters settling estates also go to the RTC if the gross estate value is over P2 million.
So it really seems like these monetary limits are key.
They are very important thresholds. And for pretty much all other kinds of civil lawsuits, if the demand or the property value is over P2 million, and that's excluding interest, damages, fees, and costs, it starts in the RTC.
Okay, that makes sense. These financial thresholds are the signposts for where to file.
Precisely. But, before you even step into a courtroom for many types of disagreements, there's another really important layer.
Ah, you mean the barangay level, the Katarungang Pambarangay law.
Exactly.
Yeah.
RA 7160. For certain cases, you have to try and settle things there first.
Right, compulsory conciliation. How does that work broadly?
Well, the barangay secretary plays a key role. They act as the secretary for the Lupan, which is the conciliation body. They record mediation results, report outcomes to the courts.
And there's a panel involved, too, the Pangkat.
The Bangkat and Tagapagkasundo, yes. A conciliation panel. 3 members chosen from the Lupan. Ideally, the parties agree on who.
And if they can't agree?
Then the Lupan chair, usually the Punang Barangay, picks them by drawing lots. Pretty straightforward.
Okay. And once there's a settlement or an arbitration award?
The Lupan secretary sends it to the city or municipal court within 5 days.
So there's a formal link to the court system even then. And who administers oaths during these proceedings?
Both the Punong Barangay and the Pangkat members have that authority for Katarungang Pambarangay matters.
What kinds of cases can the barangay actually handle jurisdiction-wise?
Civil actions where the claim doesn't exceed P2 million. Again, that's exclusive of interest, damages, fees, costs. Also, complaints for damages up to that same limit.
So a lot of common disputes could potentially be resolved there first. Saves time, saves money, maybe.
That's the idea, but there are exceptions. Probate, admiralty, small claims, those are outside their scope.
Okay. But they can enforce their own settlements.
Yes, if the money claim is over P1 Velzian hours, and if the barangay hasn't executed it within 6 months.
That's a useful detail. So the Barangay system is meant as a first stop, a more accessible way to handle many common issues.
It's designed that way.
And before we leave jurisdiction entirely, our sources briefly mention the Sandiganbayan.
Right. PD 1606, as amended.
What's its main job, in a nutshell?
It's a special court. Primarily handles graft and corruption cases against government officials and certain other high-ranking people. Jurisdiction depends on the official's position and the specific offense.
Okay, got it. So that gives us a good map of where different legal issues start. Now let's get into what happens once a civil case actually lands in court. Civil procedure. The 1997 rules, as amended. Where do we start?
Well, the logical place is the first documents filed, the pleadings.
Pleadings. Okay, these are the formal statements from each side.
Exactly. Your claims, your defenses. The complaint is the big one, where the plaintiff lays out their case.
Right. And then there are others. Counterclaims, cross-claims.
Yes. Counterclaims, defendant sues plaintiff back. Cross-claims, claims between defendants. Third-party complaints, defendant brings in someone else they think is liable.
And the response to all these is the answer.
The answer contains the defenses. And interestingly, you only file a reply to the answer if the answer attaches what's called an actionable document. Otherwise, no reply needed generally.
What are the absolute basics that have to be in a complaint?
Names and residences of the parties, obviously, and the cause of action, the legal reason you're suing.
Simple enough. Now, those third-party complaints you mentioned, bringing someone else in, are they always allowed?
Not always. The court needs to grant leave, permission, and it can be denied.
When might it be denied?
Well, if a third party can't be located within 30 days, or if bringing them in raises issues totally unrelated to the original lawsuit, or if it just introduces a whole new separate controversy. The court wants to avoid complicating the main case unnecessarily.
Makes sense. Keep it focused. What about mentioning official documents or actions in these pleadings? Any special rules?
Actually, the rules make it simpler. You just need to state that the document was issued or the act was done in compliance with the law. You don't have to plead all the specific circumstances surrounding it.
Okay. Now, shifting to the defendant's side, the answer, how specific do they need to be when responding to the complaint?
It's very specific. You have to specifically deny each material allegation you disagree with. And if possible, state the reasons for your denial.
So, no, just saying, I deny everything.
Generally, no. You can deny based on lack of knowledge or information sufficient to form a belief as to the truth of an allegation, and that counts as a specific denial.
But what happens if you don't specifically deny something important?
That's crucial. Material allegations in the complaint that are not specifically denied in the answer are deemed admitted. Big exception: the amount of unliquidated damages. But otherwise, failure to deny means you admit it.
That's a potential minefield if you're not careful writing the answer. Our sources also mention affirmative defenses. What are those exactly?
Affirmative defenses are reasons the plaintiff shouldn't win, even if their factual allegations are true. Think of things like lack of jurisdiction, wrong venue, plaintiff lacks legal capacity to sue, failure to state a cause of action, or failure to comply with a condition precedent, like barangay conciliation.
And these need to be raised early.
Absolutely. You must raise them in the answer. If you don't, they're generally considered waived. You lose the right to use them later.
Wow. And the court deals with these up front.
It's supposed to. The court should resolve these motu proprio on its own initiative within 30 days of the answer, or hold a summary hearing within 15 days, and then resolve them within 30 days after that.
And if the court denies your affirmative defense, can you appeal right away?
No, that's another key point. Denial of these affirmative defenses isn't subject to a motion for reconsideration or immediate appeal via certiorari. You have to raise it later, on appeal from the main judgment, if you lose the case.
Okay. Important procedural point. Now let's talk about getting these documents around, filing and service. How has technology changed things?
Well, we have both conventional personal delivery or registered mail and electronic filing and service now.
Yeah.
But some key documents still usually require the old-fashioned way.
Which ones typically need conventional filing or service?
Initiatory pleadings like the complaint and answer subpoenas, protection orders, writs. Those usually need personal or registered mail service, unless the court specifically allows electronic. Also, bulky exhibits that are hard to scan can be filed conventionally, and sealed or confidential documents too, again, unless the court permits electronic filing.
What about filing directly with the Supreme Court electronically? Any special rules?
Yes, if you file electronically with the SC, you typically submit a PDF and an affidavit promising to submit the hard copy within 24 hours. But for those initial pleadings in lower courts, you generally need express court authority to file them electronically.
So electronic is an option, but conventional methods are still mandatory for certain critical steps, especially at the beginning.
That's a good summary.
Now, once the complaint is filed, the defendant needs to be officially told. That's the summons. What's in it?
The summons formally notifies the defendant they're being sued. It includes a copy of the complaint and, if applicable, the court order appointing a guardian ad litem.
And who actually delivers this?
Primarily the sheriff, their deputy, or another court officer. But if they fail after attempts, the court can authorize the plaintiff, usually in coordination with the sheriff, to serve it. If the plaintiff is a juridical entity, like a corporation, they need to provide proof, like a board resolution, authorizing a specific representative.
What if someone, say, lies about serving the summons?
Oh, serious consequences. If misrepresentation of service is proven, the case can be dismissed with prejudice, meaning it can't be refiled, all proceedings could be nullified, and the plaintiff could face sanctions.
Okay, definitely not something to mess with. What if the summons just can't be served initially?
If it's returned unserved, the court orders the plaintiff to try other allowed methods. Failure to comply can lead to dismissal, usually without prejudice, so it could potentially be refiled.
Interesting twist. What if the defendant challenges the service, but has a lawyer?
The court might actually authorize the defendant's own counsel to serve the summons on their client.
Huh. Okay. And serving foreign companies doing business here, that sounds tricky.
It has specific rules. You serve their designated resident agent, if they have one, or a designated government official, or any officer, agent, director, or trustee found within the Philippines.
What if they're not registered or have no agent here?
Then you need court leave for service outside the Philippines. Options include personal service via a foreign court or the DFA, publication, registered mail, fax, electronic means with proof of service, or other court-directed methods.
Quite a few options there. Okay, moving through the process, let's talk motions. Our source mentions some motions that are prohibited early on in criminal cases. Can you remind us what those are about, just for contrast?
Right, it's about keeping things moving before the plea. Prohibited motions include things like a motion to dismiss on grounds not allowed by the rules, motions for a bill of particulars that don't meet requirements, motions to hear affirmative defenses pre-trial, motions to reconsider denials of those defenses, motions to suspend proceedings without a higher court order, most motions for extension of time, and motions for postponement that just seem like delay tactics.
Got it. Preventing early-stage delays in criminal matters. Now, back to civil. What about dismissing a civil case because of something the plaintiff did or failed to do?
Yes, that can happen. Dismissal due to plaintiff's fault. Reasons include failing to appear for evidence presentation without cause, unreasonable delay in prosecuting the case, or not complying with the rules or court orders.
And who initiates this dismissal?
It can be upon the defendant's motion, or the court can do it motu proprio. And unless the court states otherwise, this kind of dismissal is with prejudice. The plaintiff can't refile the same claim. Doesn't affect the defendant's counterclaim, though.
Okay, plaintiffs need to stay on the ball. Now, a really key stage, pre-trial. What's the main goal here?
Efficiency, mostly. Making the trial smoother. Often, the judge starts by referring the parties to the Philippine Mediation Center unit, if available.
For settlement.
Exactly. If mediation fails, the pretrial continues. The judge might also refer the case to the branch clerk of court for a preliminary conference.
What happens at this preliminary conference?
It's about exploring settlement again, marking exhibits, attaching copies, comparing originals, identifying undisputed facts, getting admissions, basically narrowing down the issues.
And this is all recorded.
Yes, in the minutes of preliminary conference, signed by the parties or their lawyers.
So it's very structured, aimed at finding common ground. What about gathering information before trial? Our sources mention depositions.
Depositions are a way to get sworn testimony from a witness before the trial. It can be done ex parte by one side initially asking the court. Testimony can be oral or via written questions.
Can you force someone to attend a deposition?
Yes, using a subpoena. But if the person is in prison, you need court permission first.
What if a party feels a deposition is being used to harass them or ask inappropriate questions?
They can ask the court for a protective order. The court has broad powers to prevent annoyance, embarrassment, or oppression. They could order the deposition not be taken or taken elsewhere, or only on written questions, limit the scope, keep it private, protect trade secrets, things like that.
Seems like important safeguards. Our sources also mention Petitions to perpetuate testimony. How is that different?
This is used before a lawsuit is filed, or while an appeal is pending. The idea is to preserve testimony that might be needed in a future case, or in case a retrial is needed after appeal.
So it's proactive preservation of evidence.
Exactly. You file a verified petition in the court where a potential defendant resides, explaining why you need to preserve the testimony now, who you expect to sue, who you want to depose, and what you expect them to say.
Okay. Another tool mentioned is requests for admission. How do those work?
One party sends written requests to the other, asking them to admit the truth of relevant facts or the genuineness of documents.
And there's a deadline to respond.
Yes, typically 15 days. The receiving party has to serve a sworn statement, either admitting, denying, or explaining why they can't do either. Or they can object.
What if they just don't respond?
Then the matters in the request are automatically deemed admitted. Huge consequence. But that admission is only for the current lawsuit, not for any other purpose. The court can allow withdrawal or amendment later, though.
Is there a downside to not using requests for admission?
There can be. If you fail to request admission on material facts clearly known by the other party, the court might bar you from presenting evidence on those facts later, unless there's a good reason. It encourages narrowing the issues.
So it's a strategic tool. Now let's fast forward. Trial's over. Court decides. What if you disagree? Motion for new trial or reconsideration. Grounds.
New trial could be for newly discovered evidence, crucial stuff you couldn't find before despite diligence, or errors of law or irregularities during trial that prejudiced your rights. Reconsideration usually argues the judgment is contrary to law or evidence already presented.
Are there limits on filing these?
Yes. A motion for new trial must include all grounds available that time. You generally waive grounds not included. A second motion for new trial is only allowed for grounds that didn't exist or weren't available for the first one, filed within the original period. And crucially, no second motion for reconsideration of a judgment or final order is allowed.
No second bite at the reconsideration apple. What happens if a new trial is granted?
The original judgment is vacated, set aside. The case stands for trial de novo afresh. But evidence from the former trial, if properly recorded, can often be used in the new trial.
Okay. Now, appeals from the regional trial court, Rule 41. What kinds of decisions can you appeal?
Generally final judgments or orders that completely dispose of the case or a particular matter within it that's appealable.
And what can't you appeal directly under Rule 41?
There's a list. Orders denying a petition for relief, interlocutory orders, those that don't end the case, orders disallowing or dismissing an appeal, denying a motion to set aside a consent judgment due to fraud mistake, orders of execution, certain judgments against only some parties or claims while the main case is pending, unless the court allows, and orders dismissing without prejudice.
So if you get one of those non-appealable orders, what's the remedy?
Usually you'd have to file a special civil action under Rule 65, like certiorari, arguing grave abuse of discretion.
Got it. For appealable orders, how do you start the appeal? What's the record on appeal?
Typically, you file a notice of appeal with the RTC. The record on appeal is the compilation of documents sent to the higher court. It needs the caption, the appeal judgment, chronological copies of relevant proceedings and orders related to the appeal, data showing it was filed on time, and references to evidence if facts are disputed. Needs an index if over 20 pages.
Can the trial court dismiss the appeal?
Yes. Before the record is sent up, the trial court can dismiss it if it was filed late or the docket fees weren't paid on time.
Okay. Now, there's also Rule 42. Petition for review from RTC to Court of Appeals. How is this different from Rule 41 appeal?
Rule 42 is used when the RTC was acting in its appellate capacity. So you appealed from an NTC decision to the RTC. If you want to appeal the RTC's decision on that appeal, you use Rule 42 to go to the Court of Appeals. It's an appeal of an appeal, essentially.
Ah, okay. Specific situation. What's the deadline for this Rule 42 petition?
15 days from notice of the RTC's appellate decision or denial of your motion for new trial reconsideration. File with the CA, pay fees, deposit for costs, serve copies on the RTC and the other party. You might get one 15-day extension max.
Can the CA ask for the original records?
Yes, they can order the RTC clerk to elevate the original record.
When is the appeal officially perfected under Rule 42?
For the petitioner, it's perfected upon timely filing of the petition and payment of fees. When perfected and the time for others to appeal expires, the RTC loses jurisdiction, mostly.
Mostly. What can the RTC still do?
It can still issue orders to protect non-appealing parties' rights, approve compromises, permit appeals by indigents, order execution pending appeal under certain rules, and allow appeal withdrawal before the CA takes over.
Does this Rule 42 appeal stop the judgment from being enforced?
Generally, yes. It stays the judgment. Big exception. Cases under the rule on summary procedure. Those judgments are usually immediately executory, unless the CA orders otherwise.
What if the record sent to the CA is incomplete?
The CA clerk reports it, recommends completion. The CA acts promptly. If completion is impossible due to extreme reasons, the CA can decide based on the available record if it's sufficient.
Are there deadlines for the written arguments, the briefs at the CA?
Yes. Appellant's brief is due 45 days after notice of the complete record. Appellee's brief is due 45 days after receiving the appellant's brief.
Okay. Now, what if a judgment seems fundamentally flawed due to something like external fraud, even after appeal periods are over? Rule 47.
Yes. Petition for annulment of judgments under Rule 47, filed with the Court of Appeals. Grounds are extrinsic fraud that prevented a fair submission of the case or lack of jurisdiction by the original court.
Time limits for this.
For extrinsic fraud, within 4 years from discovering the fraud. For lack of jurisdiction, before it's barred by laches or prescription.
And the petition needs specific contents.
Yes. Verified petition detailing the facts, the grounds, fraud, lack of jurisdiction, your meritorious defense in the original case, certified copy of the judgment, affidavits, supporting documents, and a non-forum shopping certification.
Right. Let's shift to enforcing judgments once they're final. Execution under Rule 39. How long do you have to execute by motion?
5 years from the date of entry of the judgment.
And after 5 years?
You generally have to file an action to revive the judgment before the statute of limitations runs out. Once revived, you have another 5 years to execute that revived judgment by motion.
Can judgments be executed while an appeal is pending? We touched on this.
Usually, appeal stays execution, but the rules allow for discretionary execution pending appeal, if the court finds good reasons. Also, several separate or partial judgments might be executed.
How do you stop a discretionary execution?
By filing a supersedeas bond approved by the court. It guarantees payment if the judgment is upheld.
Okay, the actual nitty-gritty. The sheriff attaching property, what are their duties?
Act without delay. Attach only enough non-exempt property in the Philippines to satisfy the judgment amount, unless a deposit or counter bond is posted. Crucially, levy is generally only valid if summons was properly served first, with some exceptions for diligent but unsuccessful attempts, temporary absence, non-residence, or in rem actions.
What about attaching someone's inheritance, their interest in a decedent's estate?
Serve the executor administrator, file notice with the settlement court, and serve the heir whose interest is being attached. If property is already in custodia legis, court custody, file the writ with that cotargency and serve notice on the custodian.
What if a third party claims the property being attached?
They serve an affidavit of title possession on the sheriff and the attaching party. The sheriff isn't bound to keep the property unless the attaching party posts an indemnity bond to protect the third party.
And the third party can sue on that bond?
Yes, within 120 days. If a bond is filed, the sheriff is off the hook for damages. The claimant can still pursue their claim to the property itself in the same or a separate action. The attaching party can also sue for damages if the third party claim was frivolous. No bond needed if the Republic is the attaching party.
What happens to the attached property then?
If no objection to the bond, or if the court approves it, the property is delivered to the applicant winning party after 5 days. If not delivered, it goes back to the adverse party.
And can the judgment include recovery against the people who provided these bonds?
Yes, the judgment can order recovery against the sureties on bonds filed under this rule, following the procedure in Rule 57 on preliminary attachment.
Okay, now a specific situation. Someone holds property or owes a debt, but multiple people are claiming it from them and the holder has no interest. Interpleader, Rule 62.
Exactly. It's an action filed by the disinterested stakeholder against all the claimants, compelling them to litigate the claims among themselves. Protects the stakeholder from multiple liabilities.
Very useful. Let's revisit forcible entry and unlawful detainer under Rule 70. We talked about jurisdiction, now the procedure. It's faster, right?
Much faster. Filed in the MTC. Complaint needs specific allegations and usually an affidavit. Summons serves like usual, but the answer is due in only 10 days.
And if no answer is filed?
Judgment can be rendered based on the complaint, limited to the relief prayed for, though the court can reduce excessive damages fees.
Is there a pretrial?
Yes, a preliminary conference within 30 days after the last answer. Rule 18 applies suppletorily. Failure of plaintiff to appear leads to dismissal. Failure of sole defendant lets plaintiff get judgment. Postponements are highly discouraged.
And barangay conciliation is still mandatory.
Absolutely. Failure to comply means dismissal without prejudice, revivable after compliance.
Are there specific things you can't file in these cases to keep them speedy?
Yes, a whole list of prohibited pleadings and motions. Motion to dismiss, except lack of jurisdiction non-compliance with conciliation, bill of particulars, motions for new trial reconsideration reopening, relief from judgment, most extensions of time, memoranda, certiorari against interlocutory orders, motion for default, dilatory postponements, reply, third-party complaints, interventions.
Wow, really stripped down. What about the affidavits used?
Must state only facts based on direct personal knowledge, admissible in evidence, showing competence. Violations can lead to sanctions and expungement.
Can you get immediate court orders, like injunctions?
Yes, preliminary injunction under Rule 58 to prevent further dispossession. And a preliminary mandatory injunction to restore possession can be sought within 5 days of filing the complaint, with the court deciding within 30 days.
Finally, under civil procedure topics, indirect contempt, Rule 71, punishments.
Depends on the court. RT Chire, fine up to P 30,000, or imprisonment up to 6 months, or both. Lower court, fine up to P 5,000, or imprisonment up to 1 month, or both. Violating an injunction might also require restitution, fines executed like civil judgments.
Okay, that covers a massive amount on jurisdiction and civil procedure. Let's shift gears to special civil actions. What makes them special?
They have their own specific rules, distinct from ordinary civil actions. They address particular kinds of legal issues and often have unique procedures.
First up, certiorari under Rule 65. When do you use this?
When a lower court, board, or officer acting judicially or quasi-judicially acts without jurisdiction in excess of it, or with grave abuse of discretion amounting to lack or excess of jurisdiction. Crucially, there must be no appeal or any plain, speedy, and adequate remedy available in the ordinary course of law.
So it's not a substitute for appeal?
Definitely not. If appeal is available, that's usually the route.
What goes into the certiorari petition?
Verified petition, alleging facts with certainty, praying for annulment modification. Needs a certified true copy of the challenge judgment order, relevant pleadings, documents, and a non-forum shopping certification.
Next, quo warranto, Rule 66. What's this about?
It's an action, usually by the Republic, challenging someone's right to hold a public office, position, or franchise, or against an officer who forfeited their office, or an association acting as a corporation without authority.
Can an individual file it?
Yes, if they claim entitlement to the public office that's allegedly being usurped by someone else, they can file the action in their own name.
And the petition needs to state
the name of the person claiming rightful entitlement, aver their right, and state how the respondent is unlawfully holding the position. All claimants can be joined.
Moving to expropriation, Rule 67 and RA 10752. Government taking private property. 2 stages, right?
Yes. First, determining the authority to expropriate. Second, determining just compensation. RA 10752 speeds things up for national government infrastructure projects, especially getting possession.
How does RA 10752 facilitate quick possession?
The government deposits an amount with the court based on assessed value of land, replacement cost of structures, market value of crops, trees. Once deposited, the court must issue a writ of possession within 7 working days, often ex parte. The money is released to the owner upon proof of ownership.
What costs are included in just compensation under this act?
It's broad. Value of land structure scrops plus costs of surveys, appraisal, resettlement, capital gains tax if negotiated sale, documentary stamp tax, transfer tax, registration fees, and administrative expenses.
Okay. Foreclosure of real estate mortgage. Rule 68 and Act 3135. 2 main types.
Judicial foreclosure under Rule 68, court process, and extrajudicial foreclosure under Act 3135. Outside court following specific procedures, often outlined in the mortgage agreement itself.
What recourse does the debtor have after an extrajudicial foreclosure sale?
Under Act 3135, within 30 days after the purchaser gets possession, the debtor can petition the court to set aside the sale and cancel the writ of possession. Grounds: mortgage wasn't violated or the sale didn't follow the law. It's a summary proceeding. Appealable, but possession usually stays with the purchaser pending appeal.
Partition next, Rule 69. Dividing co-owned property. When does this go to court?
When co-owners, like heirs, can't agree on how to divide real estate they own together and physical division is feasible.
And the court appoints commissioners.
If the parties can't agree on the division themselves, yes. The commissioners propose a partition plan in a report. The court can accept, reject, recommit, or modify the report.
What about costs?
The court taxes the costs and expenses, including commissioner fees, and apportions them equitably among the parties.
And the final judgment.
It either specifies the partitioned portions with metes and bounds, vesting ownership individually, or orders the whole property assigned to one party upon payment to others, or confirms a sale to a third party. A certified copy gets recorded.
Last special civil action mentioned was forcible entry unlawful detainer. We covered the procedure, but why is it special?
Because its primary goal is the speedy resolution of the issue of physical possession, not necessarily ownership. The streamlined rules, the prohibited pleadings, it's all geared towards that quick resolution.
Right. Focus on possession. Okay, let's dive into special proceedings. How are these different from civil actions?
Generally, they establish a status, a right, or a particular fact, often less adversarial than a typical lawsuit, governed by specific rules.
Settlement of estate of deceased persons, Rules 7390. What's summary settlement of estate of small value?
If the gross value of the estate doesn't exceed P10,000, interested parties can petition for a summary settlement. It's faster, avoids appointing an executor administrator, involves a hearing after publication, court determines heirs, allows will, partitions estate after debts paid.
What if an heir or creditor is missed in this summary process?
They have 2 years after distribution to file a claim. The court can compel the distributees to contribute to satisfy the claim. A bond might be required if non-real property was distributed.
Challenging a will allowance or disallowance under Rule 76. How does one contest?
File grounds of opposition. If contested, subscribing witnesses, and the notary, if applicable, generally must be produced if available. But the court can still allow the will based on other evidence even if witnesses are forgetful or testify against it, if satisfied of due execution and testator capacity volition. A certificate of allowance is attached and recorded.
How are claims against the estate handled? Debts owed by the deceased.
Filed with the court. Executor administrator answers. Contested claims go to trial, can be referred to a commissioner. Judgment is appealable, paid in due course of administration, no automatic lease or priority.
What if someone's hiding estate property?
The court can compel them to appear and account for it under penalty of contempt.
Can the estate be kept open for potential future claims? Contingent claims?
Yes, the court can order retention of assets for contingent claims. If they become absolute within 2 years, procedures exist for allowance and payment. If later, creditors might pursue distributees directly.
Okay, guardianship next. Rules 9297. Appointing a guardian for minors or incompetence. How does it start?
File a petition. Notify specified persons. Minor if over 14, alleged incompetent relatives. Opposition is allowed. Hearing required. Alleged incompetent must attend if able. Court appoints a suitable guardian of persona state or both. Can also appoint for non-resident with property hereafter notice.
What are the ongoing duties?
File inventory within 3 months. Annual inventory and accounting thereafter, compellable by interested person. Estate appraised. Bond required for parents as guardians if property value income exceeds P50,000. Bond at least 10%. Manage property frugally. Support ward. Get court approval for sale encumbrance or partition.
Now, adoption. Big changes here with RA 1142, the Domestic Administrative Adoption Act. What's the headline change?
The creation of the National Authority for Child Care, NACC. It now has original and exclusive jurisdiction over most alternative child care matters. Declaring child legally available for adoption, CDCLAA, domestic administrative adoption, adult adoption, foster care, simulated birth rectifications, intercountry adoption. It's shifted largely from judicial to administrative.
So the courts are mostly out of the adoption process now.
For new domestic adoptions, largely yes. The NACC handles it. They issue the CDCLAA, which is the key document proving a child is legally free for adoption. The law defines key terms like abandoned, neglected, foundling, etc.
How do you get that CDCLAA?
File an affidavit petition with supporting docs, social case study, proof of search for parents with the NACC. Decision within 15 working days, appealable to the CA within 10 days.
And the actual adoption process after CDCLAA?
Counseling for all parties is mandated. Then, a 6-month supervised trial custody, STC. If successful, a petition for adoption is filed administratively. The process involves document review, interviews by the regional office, RACC, no adversarial court hearings, decision within 60 days of RACCO recommendation.
Can an administrative adoption be undone, rescinded?
Yes, a petition for rescission can be filed. If granted, NACC can restore biological parental authority, if best for child and requested, or take legal custody.
The law also mentions confidentiality and trafficking.
Yes, penalties for violating confidentiality of records. stiffer penalties for acts constituting child trafficking. Importantly, it doesn't affect prior judicial adoptions. It repealed older adoption laws. There were also interim rules for pending court cases, allowing withdrawal to file administratively with NACC.
A massive shift indeed. Okay, habeas corpus, Rule 102, the great writ purpose.
To inquire into the cause of someone's detention, a remedy against unlawful imprisonment, filed by the person detained or someone on their behalf, verified petition with details.
And the writ requires.
It directs the person holding the detainee to bring them before the court and justify the detention. If found unlawful, the person is released and generally can't be re-imprisoned for the same cause without lawful court order. Penalties for illegal re-imprisonment exist. Clerk keeps records.
How is habeas data different? AM Nover 08116 SC.
Habeas data protects the right to privacy in one's data or information against unlawful acts or omissions. Also starts with a verified petition, needs supporting evidence, non-forum shopping cert,
Procedure.
personal service of summons. Only motion to dismiss allowed is lack of jurisdiction. Other defenses in the answer due in 5 working days. Summary hearing. Interim reliefs like TROs, inspection protection orders possible. Hold departure order for a minor subject possible without prior hearing. Judgment in 10 days appealable to SC. Can be consolidated with related cases.
Then there's a writ of imparo, AM Note 07912 SC. For what situations?
For violations or threats to the right to life, liberty, and security by unlawful acts omissions of public officials, employees, or private entities. Specifically covers extra-legal killings, enforced disappearances, or threats thereof.
Who can file? Procedure.
Aggrieved party or specified relatives concerned citizens. Verified petition. Return due in 5 working days. Summary hearing. Inspection production orders possible. Contempt penalties apply. Judgment in 10 days, appealable to SC. Rules of court apply suppletorily. Can be filed with higher courts, retop public data files. Penalties for refusing to issue serve writ. Can be consolidated with criminal cases.
Getting near the end of special proceedings. Change of name, Rule 103. Process.
Verified petition in the RTC of petitioner's residence. Court orders hearing requires publication, once a week, 3 weeks. Hearing date restrictions relative to elections publication. Any interested person can oppose. Solicitor General Fiscal represents government. Judgment granted if proper cause shown and allegations proven.
We don't have details on Rule 108, cancellation correction of civil registry entries, in the excerpts, but the purpose is
to provide the legal process for correcting errors or making legitimate cancellations in official civil registry records, birth, marriage, death certificates following specific procedures.
Finally, the rule of procedure for environmental cases, AM Nomo 79-8 SC, key features.
Designed for faster, more effective handling. Defines terms, mentions precautionary principle, limits allowable pleadings motions to speed things up, prohibits motions to dismiss, bill of particulars, etc. Allows for temporary environmental protection orders, TEPOs. Aims for trial decision within 1 year, extendable by SC. Prioritized adjudication. Court can appoint commissioner to monitor compliance. Citizen suits for widespread damage have no docket fees. Ocular inspection possible. Preliminary conference focuses on settlements, stipulations, etc. Official records are prima facie evidence.
Okay, that's a thorough run-through of special proceedings. Now into the final major section, criminal procedure. Rule 110, prosecution of offenses. Who's in charge?
Criminal actions initiated by complaint or information are prosecuted under the direction and control of the public prosecutor. Exception. In MTC, SMC, TCs without a prosecutor, the offended party, any peace officer or designated public officer can prosecute temporarily.
What makes a complaint or information legally sufficient?
Needs the name of the accused, designation of the offense by statute, the acts omissions constituting the offense, name of offended party, approximate date, and place of commission. Must include all participants. Alias is okay if real name unknown.
What's duplicity of offense?
Generally, one complaint information should charge only one offense. Avoids confusion. Exception. When the law prescribes a single punishment for various offenses, complex crimes.
Can the charges be changed after filing, amendment or substitution?
Yes. Amendment, formal or substantial, is allowed without court leave before plea if no prejudice to accused. But downgrading the offense or excluding an accused before plea requires prosecutor's motion, notice to offended party, and court leave with reasons stated.
What about crimes committed outside the Philippines but punishable here under the RPC? Where is the case filed?
Jurisdiction lies in the court where the criminal action is first filed.
Can the victim participate actively?
Yes, the offended party can intervene by counsel in the criminal action if seeking civil liability arising from the crime.
How important is correctly naming the offense?
Very. Complaint information must state the statutory designation, the act's omissions, and any qualifying aggravating circumstances. If no specific name, cite the law violated.
Are there filing fees in criminal cases?
Yes, for certain damages claimed by the offended party, moral, nominal, temperate, exemplary, but not for actual damages. No countercross third-party complaints allowed in criminal cases. File related civil action separately. Exception, BP 22, bouncing checks. Action includes the civil aspect. No separate reservation allowed.
Okay. Preliminary investigation, Rule 112. Purpose.
To determine if there is sufficient ground to believe a crime was committed and the respondent is probably guilty, justifying holding them for trial.
What happens initially?
Investigating officer reviews complaint evidence. Within 10 days, either dismisses or issues subpoenas respondent with complaint evidence copies. Respondent has right to examine complainant's evidence.
Arrest without warrant, Rule 113. When is it lawful?
3 main instances. 1, in flagrante delicto, caught in the act. 2, hot pursuit, crime just committed, probable cause based on personal knowledge. 3, escaped prisoner. Arrested person delivered immediately to nearest police station jail.
Search and seizure, Rule 126. What happens to seized property?
Officer delivers property immediately to the issuing judge with verified inventory. Judge ensures return is filed, logged, property properly delivered, safeguarded. Failure is contempt.
We also have the rules on cybercrime warrants. AM number 17-1103. Where are these filed?
Generally, with designated cybercrime courts where crime occurring about to occur or where system is damage occurred. Special authority for certain major city cybercrime courts to issue warrants enforceable nationwide overseas.
And these rules define specific cyber terms.
Yes, things like content data, cybercrime court, forensic image, hash value, interception, offsetting site search, preservation service provider. Specific procedures and affidavit requirements for disclosure, interception, search, seizure, examination of computer data.
Bail. Rule 114. When is it discretionary after RTC conviction for non-capital offenses?
The trial court has discretion after conviction, but before transmittal of record on appeal. If conviction changes offense nature making it bailable, then apply to the appellate court.
What about release on recognizance, RA 10389?
For indigent capacitated accused post-arraignment. Motion required, needs sworn declaration of indigency, DSWD certification, notice to local counsel, 10 days to comment, other conditions. Release to a qualified custodian.
When can someone released on recognizance be rearrested?
Non-appearance, commission of new offense, violation of conditions, or custodian's death incapacity insolvency.
Arraignment and plea, Rule 116. What happens exactly?
In open court, judge clerk reads complaint information in language understood by accused, asks for plea, guilty, not guilty. Prosecution can call unlisted witnesses. Private offended party must appear for plea bargaining, civil liability determination, etc. If offended party fails to appear despite notice, plea bargain to lesser offense might be allowed with prosecutor's consent. Arraignment within 30 days of court acquiring jurisdiction, less certain delays. Counsel de officio appointed for grave offenses complex cases if accused has no lawyer.
Motion to quash, Rule 117. Grounds.
List includes court lacks jurisdiction, facts don't constitute offense, charge is duplicitous, criminal action liability extinguished, contains prejudicial averments, double jeopardy.
Tricetion evidence, then defense evidence, then rebuttal, then surrebuttal. Submitted for decision after evidence admission unless oral argument memoranda ordered. Order reversed if accused admits act but pleads lawful defense. Cases can be archived if accused at large 6 months post-warrant or proceedings suspended indefinitely for valid reasons. Motion for new trial or reconsideration in criminal cases. Rule 121. Grounds. Written.
Grounds. Newly discovered evidence, these affidavit stocks, errors of law or irregularities prejudicial to accused. Motion must be written. State grounds. Notice to prosecutor. Court can hear evidence on factual issues.
Now, evidence rules. Rule 133. Weight and sufficiency. Standard in criminal cases.
Proof beyond reasonable doubt. Much higher than preponderance of evidence in civil cases. Rules list disputable presumptions, like innocence, that evidence must overcome.
Rule 129. Judicial notice. Things courts accept without proof.
Existence territory of states, political history, forms of government, international law, Philippine Constitution, official acts, laws of nature, measure of time, geography.
Admissions and confessions. Admissibility.
Parties' act declaration omission against interest is admissible against them. Offer of compromise in civil cases generally not admission of liability. Extrajudicial confession admissible against confessant only unless conspiracy independently shown.
Privileged communications.
Examples.
Examples.
Attorney-client with exceptions. Physician-patient, minister-priest, penitent, public officer regarding official confidence if public interest requires secrecy.
Hearsay rule and exceptions. Hearsay is generally out, but exceptions include
Dying declaration, declaration against interest, declaration about pedigree, family reputation, common reputation, part of res gestae, entries in course of business, entries in official records, learned treatises, former testimony, residual exception, if trustworthy, records of regularly conducted business activity, also an exception.
Rule 132, impeaching witnesses. How?
By adverse party. Can impeach own witness if hostile, unwilling, or adverse party, but not by bad character evidence usually. For prior inconsistent statements, confront witness with circumstances, allow explanation, show written statement before questioning.
Competency of child witnesses.
Presumed competent. Competency exam only if substantial doubt, re-ability to perceive, remember, communicate, distinguish truth, falsehood, appreciate duty to tell truth. Rules define child witness, guardian ad litem, support person, best interests.
Our sources mention but don't detail the judicial affidavit rule and rules on electronic evidence. Briefly, what are they?
Judicial affidavit rule generally requires direct testimony submitted via sworn Q&A affidavit before trial to speed things up. Electronic evidence rules govern admissibility use of electronic docs data messages, define terms, e-doc, digital signature, set presumptions, religioni signatures, cover transcripts, storage.
And finally, rules on use of body-worn cameras. AM number 210608 SC. Key points.
Procedures for using body cams alternative devices during warrant execution. Recordings stored, copy deposited with court. Officer's affidavit required reuse, malfunctions. Failure to use without reason may render evidence inadmissible. Tampering is contempt. Limited access to recordings, subject counsel, etc., but recordings of incidents involving death assault on officers are public record.
Wow. Okay. That was truly a deep dive. We went through so much based on those CODIGO Remedial.pdf excerpts you shared. Jurisdiction, the whole flow of civil procedure pleadings, summons, pretrial motions, appeals, execution.
Right. And the special civil actions, certiorari, quo warranto, expropriation, foreclosure, partition, forcible entry, unlawful detainer.
Then special proceedings like settling estates, guardianship, that whole new administrative adoption process, habeas corpus, data, amparo, change of name, environmental roles.
And finally, criminal procedure, prosecution, complaints, arrest, search, bail, arraignment, trial, evidence rules, including the newer ones on electronic evidence and body cams.
It really was a tailored exploration, focusing just on the material you provided.
Exactly, a focused look based on those specific texts.
I hope you, our listener, had some, aha moments or found some surprising connections in there. It's pretty eye-opening seeing the level of detail.
And how these rules keep evolving. That point about specific denial in an answer, for instance, get it wrong and you've admitted something crucial.
Yeah. Or the new adoption process, RA 11642. That seems like a really fundamental shift.
It absolutely is. And remember, this overview, detailed as it was, is still just a starting point. Each area warrants much deeper study depending on your specific needs or interests.
Definitely. So as we wrap this up, here's maybe a final thought to chew on. Considering just the sheer scope and, let's face it, complexity of these legal frameworks we've touched upon, what does that mean practically for individual rights and genuine access to justice here in the Philippines?
That's a big, important question. Something definitely worth pondering.
It is. Until our next deep dive, keep exploring.